Okay, so we got to talk about this trial in Georgia where it seems like everyone is going to jail. Like, here's a juror who had to go to jail.
The judge slaps a potential juror with jail time. Her offense, shooting video of courtroom proceeding.
One of the court officers also went to jail.
Developments tonight involving yet another twist in this ongoing YSL RICO case. We're talking about a Fulton County Sheriff's deputy arrested earlier today and accused of trying to smuggle contraband to a defendant in the case. This deputy, Akiba Stanley, in this mugshot here.
And even the lawyers have been having problems. Here's one defense attorney who the judge said, because you're late, you got to either write me a paper or you got to go to jail.
Next matter, Mr. Johnson. How are we doing on that paper? I mean, the importance of professionalism. Yours is due by the 28th of April. I'm just checking, just clocking. So we on track?
Haven't started.
Well, your better half said she's not writing it for you either. Okay, well, just want to let you know that, okay? All right, so we're good? I'm sorry? Because that wasn't offered to you. You already asked me, could I pay the $1,000? I told you no. Well, I know you would, but that's not what's on the table.
So, you said 28, right?
28, yes, at noon. Or you do 20 days. It's 17-page paper on the importance of professionalism in the legal field and treating one's opponents with civility. Paper is to be published quality in APA format and at least 10 primary and 10 secondary sources. Means that we should be able to send it to the to either the Georgia, any one of our law review or any other place that accepts publications, and it should be acceptable.
Just so you understand, it was either 20 days in jail or write a 17-page paper. Now, even though that guy was threatened to be put in jail, we got two other lawyers who actually were put in jail.
News now at noon, a defense attorney with the YSL RICO case has been arrested. Officials say attorney Astasios Menetas was arrested this morning in the Fulton County courtroom. This is video of when we spoke to him earlier this month. We're told he's facing several charges, including simple battery on a law enforcement officer, obstruction, and disruption of court proceedings.
Nicole Fegan, she was arrested today in Gwinnett County stemming from a September 2022 deadly shooting in downtown Atlanta, not far from Centennial Olympic Park. Fegan is not accused of shooting anyone, but Atlanta police say investigators learned she contacted a suspect in the shooting and told him there was a warrant for his arrest. Investigators say she learned about that during a court hearing related to the shooting. Police say she told the suspect, who they aren't identifying, to dispose of his phone as police were going to arrest him. Detectives say Fegan was not representing the suspect that she called. She faces 2 charges: participation in criminal street gang activity and solicitation to tamper with evidence. Fegan represents YSL defendant Tinquarius Mender.
And now we have another defense attorney who has been arrested and sent to jail for 20 days.
An explosive day in the YSL racketeering trial at the Fulton County Courthouse. In the past 2 hours, the presiding judge held Young Thug's attorney Brian Steele in contempt. Cameras were rolling as attorney Steele removed his jacket and got placed in custody.
Welcome to Atlanta, Georgia. This is Young Thug, and he's on trial for violating Georgia's RICO laws.
Young Thug, whose real name is Jeffrey Lamar Williams, is one of 28 defendants charged in a sweeping 56-count indictment against the criminal street gang Young Slime Life, also known as YSL. The charges ranging from conspiracy to violate the Georgia criminal racketing law, murder, armed robbery, and aggravated assault with a deadly weapon. According to the indictment, YSL is a criminal street gang started in late 2012 in the Cleveland Avenue area of Atlanta. Prosecutors say Young Thug is a co-founder, and he and his affiliates have played a role in some of the city's most violent crimes.
Me and the mayor and the police chief have talked about the fact that Cleveland in our community is referred to as Bleveland.
Also named in the indictment is Jimmy Carlton Winfrey. He's serving a 20-year prison sentence after pleading guilty to firing shots at rapper Lil Wayne's tour buses as they traveled on I-285 in April of 2015.
Now, fast forward a couple of months, and we are in the middle of trial. Now, the state has a star witness who was involved in the YSL madness. That star witness's name is Kenneth Copeland. Kenneth Copeland also goes by the name Little Woody, and he was supposed to testify against the YSL gang. Now, if you're in the United States, you know you have the Fifth Amendment right against self-incrimination.
Sir, is it true you were a crack cocaine dealer for 7 years?
I plead the fifth. Now, there is a way around the Fifth Amendment, and that way is if the government gives you immunity from prosecution. In other words, if the government says no matter what you say, you will not be charged with any crimes. We're going to give you immunity in exchange for your testimony. So now you can't plead the Fifth because you're not going to self-incriminate yourself since you can't be charged. So now that brings us to Kenneth Copeland, aka Little Woody. See, Little Woody was given immunity by prosecutors, and that immunity forced him to testify about the crimes that he committed because prosecutors were not going to charge him with any of those crimes. He had been given blanket immunity for any of the criminal activity that he had done during his YSL stint. So on Friday, prosecutors called Little Woody to the stand and started asking him questions about his criminal activity, understanding that anything he said he would be immune from. Let's say if he told prosecutors he killed somebody, well, they wouldn't be able to prosecute him for that confession because he's been given immunity from prosecution. So this is what happened when they called Little Woody to testify on Friday.
Key witness in the YSL trial arrested on the stand after refusing to testify.
Kenneth Copeland, aka rapper Little Woody, was not the cooperative witness that prosecutors had hoped for.
The state's next witness in the YSL trial, Kenneth Copeland, aka rapper Little Woody.
Mr. Copeland, come on up and have a seat here, sir.
But before the jurors were called in, Copeland's attorney says his client planned to invoke his Fifth Amendment right to avoid self-incrimination.
What he has told me is that he repeatedly told the DA's office that he did not wish to cooperate, did not wish to testify.
The judge told Copeland there's an order granting him immunity which prevents his testimony from being used against him, which means...
So you're required to testify. So if you don't testify, the state's probably going to ask me to jail you. And I'm probably going to do that.
The judge was true to his word. After a lunch break, Copeland did testify briefly.
Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
But when the state asked exactly how old he was,
I plead the fifth.
Ladies and gentlemen, can I get you to step outside?
That's when the judge ordered Copeland to be handcuffed.
This court holds you in willful contempt, and we'll see you on Monday.
And Kenneth Copeland remains in custody this evening and throughout the weekend. He's been asked to return on Monday morning when the trial resumes and will once again be asked to testify.
Okay, so just as you saw, Little Woody was on the stand, he was sworn in, and he essentially refused to answer any questions. He didn't want to be a snitch, even though the prosecutor granted him immunity. And as you saw what the judge said, hey, you have to testify because you are not in jeopardy of anything. You can't self-incriminate yourself because they will not prosecute you. So the prosecutor then asked the judge for what's known as an ex parte communication. In other words, the prosecutor wanted to speak with the judge alone outside of the presence of the defense counsel, and they wanted to speak to the judge with Little Woody present. Now, this runs afoul of some courtroom procedures because generally, if a witness has been sworn in and is on the witness stand, then one side can't have ex parte communications with that witness because the witness is in the middle of testifying. Little Woody was literally on the stand testifying. So any questioning from the judge or from the prosecutor would have to be done in the presence of the defense counsel. But now the judge and prosecutors had a conversation with Little Woody outside of the presence of the defense counsel. And that conversation was essentially, if you don't testify, you're going to be in a load of trouble because we're going to lock you up for almost ever because you are bound to testify because you have an immunity deal. Now, the defense attorney didn't know any of this was happening. But somebody essentially told the defense counsel all of this information. And the defense counsel then goes to court and makes a big stink out of it because they want to know why was Little Woody questioned behind closed doors without defense counsel, because the defendant has a right to confront all their accusers. So now we're going to pick it up to where Young Thug's defense counsel, Mr. Steele, is going to confront the judge about this ex parte communication, says it violates his defendant's rights, and that he wants a mistrial because he wanted to be in the room when this witness gave testimony, and also the fact that this witness was threatened with jail time if he didn't testify. Now remember, every time they say Mr. Copeland, they're talking about Little Woody.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment.
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to answer you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016.
All right, so let me read to you what this case says. Here it is, Scudder v. State 2016. And this is what the court in Scudder said. So in Scudder, very similar facts occurred. Scudder claims that the trial court in his case erred when the judge met privately in his chambers with the witness. The witness felt, quote, her neighbors might consider her to be a snitch. Sounds familiar. The court then gives us the law that all the lower courts must follow. Quote, that a criminal defendant has the right to be present and to see and hear all critical parts of his trial. Then the court goes on and said it is a right that may be relinquished, however. And now it's going to give us a list of ways that it can be relinquished. If the defendant personally waives it in court, if counsel waives it at the defendant's express direction, if counsel waives it in open court while the defendant is present, if counsel waives it and the defendant subsequently acquiesces in the waiver. So now the Georgia Supreme Court has said there has to be some type of waiver. And that waiver could be obtained in those particular ways that we just discussed. It's so important that the defendant be there. The Georgia Supreme Court considers it a fundamental right and a foundational aspect of due process of law. Okay, obviously we are about to get deep into this case. Hell, I'm reading case law from Georgia in 2016. That's how deep we're getting in this one. Now, as you can see, Grammy Award winner Young Thug has paid for some of the best representation money can buy, and everyone should have a great lawyer to represent them. Now, if you're watching this video and you've been injured in an accident, me and my team may be able to help you. Call me at 571-NATE-LAW. That's 571-NATE-LAW. We handle everything from car accidents to cases involving the aqueous film forming foam. That's the foam that firefighters use to put out chemical fires, but it's also been linked to some serious health issues like cancer. Now, you can give us a call at 571-NATE-LAW, that's 571-NATE-LAW, or you can visit the website at natethelawyer.com. That's natethelawyer.com. Remember, the advice is free, the consultation is free, and we don't get paid unless you win your case. So now, YSL's attorney is going to either argue that they, number one, didn't give any type of waiver, and number two, because there was no waiver, they had a right to be in that room when the judge talked to this witness who had just gotten off the stand.
Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said.
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Now I want to stop it here for one particular reason. It's not really even relevant how he got the information. The law in Georgia seems to be clear. If you're going to have an ex parte communication with the witness, the defendant has a right to be there unless the defendant waives that right. That's the only way that judge could have met with that witness and it be okay at this particular time, based on the case law of Shutter v. State. So where he got the information is essentially irrelevant until we ask the question, did you have that meeting? And we know they did have that meeting. So now, has the defendant's rights in this case been violated because the judge had an ex parte meeting with the witness outside the presence of the defendant? Because don't forget, the court says that's a fundamental right of due process.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
I just want to remind people, the defense attorney has the right to that information unless they waive it. Now, there's nothing here that I've heard that even suggests that the defendant has waived anything. But the judge is now saying you didn't have a right to it. He doesn't even listen to the case law. But if Shutter v. State is the case on point, then it seems like the defendant had a fundamental right to that information.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of.
So now, going back to Shutter v. State, is that a critical part of his trial? The fact that the state's key witness, who's just come off the stand, is now saying they'll be locked up for 2 years if they won't want to testify. I think that's extremely critical. I think it's ridiculous not to think it's critical. I think the judge needs to address the legal part that he's bringing up because he seems to be on point, but the judge doesn't care. Tell me who the snitch is or you're going to jail.
That's true. What this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I
tell you what, I'm going to give you 5 minutes. If you don't tell me if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told, Mr.
Now, this is crazy because this lawyer's like, I have the case that explains all of this, but the judge doesn't want to hear it. The only thing he wants to know is who told him the information. So, fast forward 5 minutes, and this is what's happening.
Okay, Mr. Steele, would you take the podium, please, sir? Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it.
Let me tell you, I'm just reading from it, but if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt.
So on one side, you got the judge who's saying, hey, I don't care about the information itself, just the source of the information. And now you have the client saying, well, the source of the information is the information that I'm trying to protect.
I'm not going to have
When I got this information,
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
Now, I know. This has been between the defense attorney and the judge, but the prosecutor gets to speak. And here's what the prosecutor said. This is her defending the ex parte communication.
The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that.
So now this woman cites no case. She just rambles for another 20 minutes, which I just saved you from and pointed you to the most important part. Now she's going to ask for the defense attorney's whole thing to be struck based on feelings.
And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6.
So the prosecutor made their argument. The defendant has made his argument. If I'm the judge, to be honest with you, I'm going with the defense side because he's got law to back him up. We read the case. It seems to make sense, but we will see. Now, interestingly enough, the defendant, YSL's second attorney, goes to the podium and essentially says the same thing as the first guy, even to the point where he's like, if you lock him up, you got to lock me up too.
Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay, yeah, he does, but
The court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial. as he did previously. And I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
All right, sir.
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams. And if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well, I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that.
So now we're not done. Mr. Steele gets his own attorney to argue his case for him in front of the judge. This is Ashley Merchant. Here she goes.
Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them, by nature.
Okay.
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute, but I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
Yes, Judge. There's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'm going to take 5 minutes out and I'm going to think about it.
Thank you.
Okay. All right. So we'll be in recess about 5 minutes.
Now, the judge takes like an hour. Then the judge comes back and gives his final verdict.
All right. Thank you, sir. Okay, Mr. Schuster as well. All right, counsel, I've made a clarification to the order of contempt. Mr. Steele, I am going to hold you still hold you in summary criminal contempt pursuant to OCGA 15-1-3. Subpart 3 for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated in the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence
this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024 at 7 p.m., subject to further order of this court. And that will be entered and e-filed, and you may take whatever steps you and your counsel deem appropriate.
So at the end of the day, he was still given the jail time. Now, after all that happened, we got to get back to Little Woody. So Little Woody did testify, and listen to the way he answers the questions.
While y'all were in school, did y'all develop a friendship?
Nope.
Okay. At some point in time, did you ever develop a friendship with Shannon?
Yeah.
Okay. When was that?
I don't know when, but at one point we became cool.
Okay. And when you say cool, what do you mean?
COOL.
I didn't ask you to spell it. I asked you what you mean.
Well, we became cool. I don't know what you mean. I don't know.
Did you look at him as a brother? Was he an acquaintance? Was he just someone you talked to on occasion? When you define cool, what was your relationship like with him?
Oh, just a dude in the street.
That's it? Did that develop over time?
Say that again?
You said he was just a dude in the street. Did that relationship develop over time? Where he became more than just a dude on the street?
I guess.
Okay, so a lawyer went to jail just for that. Okay, let's recap. Rapper Little Woody, Kenneth Copeland, didn't want to rat out his friends. So the state gave him immunity and forced him to testify. He refused to testify on Friday, went to jail, came back Monday, and then had to testify. During the time where he refused to testify and when he was forced to testify, he had a private conversation with the judge. The defendant had a constitutional right to be in that room to hear that conversation. That didn't happen, and this lawyer was held in contempt for bringing that to the judge's attention. As always, tell me where I'm wrong in the comment section. Tell me, hey Nate, you got this one wrong. But to me, it seems like this judge overstepped. Seems like the law is clear that the defense attorney should have been in that room to hear that conversation. And the judge holding this man in contempt because he won't tell him who told him is really childish, and it really makes the court look bad. On your way out, don't forget to like, share, subscribe, do all that great YouTube stuff. My name is Nate, the lawyer, and I'll see you in the next one. Peace.